Good morning. I'm Adam Lupel, IPI Vice President. It is my honor to welcome you to this morning session on political obstacles to the rule of law and human rights. As you may know, this is organized as a side event to the UNDP annual meeting. Thank you. On strengthening the rule of law in crisis-affected situations. And it is indeed our pleasure to partner with UNDP on this event in cooperation with the Folke Bernadotte Academy. The rule of law as a topic has long been a part of IPI's work, in my memory at least, since the early 2000s Rule of Law project that produced an edited volume on civil war and the rule of law that some might remember. And up until most recently, last year's IPI's inaugural Salzburg seminar was held on the topic of the rule of law and the laws of war. And then most recently, IPI's Independent Commission on Multilateralism, some of you may have taken part in some of our events on that. We have taken justice and human rights as one of our 16 key issue areas. So we can all agree that this is a critical topic for a critical time. Although this is not the time for me to speak, we have others to do that right now. Before we move to our panel discussion, we will have two welcoming remarks. First by Ms. Seema Sami Bahus, Assistant Secretary General, Assistant Administrator, and Director of the UNDP Regional Bureau for Arab States. And then from Mr. Taye Brook Zerhoun, Assistant Secretary General for Political Affairs of UNDPA. Afterwards, we'll move to our panel discussion and then have a Q&A. So without further ado, I pass the floor to Ms. Bahus. The floor is yours.
Good morning, everyone, and thank you very much. I would like to welcome you all to this session of UNDP's annual meeting on rule of law in crisis and fragile settings that we have dedicated to exploring political obstacles to rule of law and human rights. Let me express my appreciation first to the Folke Bernadotte Academy and to the International Peace Institute for organizing this event with us. Today, we will discuss, as was mentioned, the linkages between politics and our assistance in the rule of law and human rights. A better understanding of these dynamics is essential to our success in supporting genuinely durable peace and sustainable development in politically complex settings. As you know, strengthening the rule of law is inherently a political process as it deals with the very foundations of power in societies, especially in those that are emerging from crises and facing major questions of legitimacy and accountability. As with any process of political change, efforts to strengthen the rule of law in crisis or fragile settings will challenge prevailing power structures as they seek to redefine the rules of the game. Under these circumstances, those engaged in supporting the rule of law will naturally face a range of deeply entrenched political obstacles as we go about our work. The support that we provide must go beyond technical assistance, such as supporting changes to legislative frameworks or developing capacity of key institutions. Rather, our focus, we believe, should also be on understanding the broader political context and dynamics and how various interests at play will facilitate or limit the pace and contours of the reform process we seek to support through our rule of law and human rights engagement. Solid and ongoing conflict and political analysis is therefore an important tool in our overall approach. The importance of politics for achieving peaceful and sustainable development is not only the view of so many in this room, but it is also firmly reflected in Agenda 2030, notably in Sustainable Development Goal number 16, with its call for access to justice for all and effective, accountable, and inclusive institutions at all levels. Over the past year, UNDP has been engaged in a research project together with the Folke Bernadotte Academy to identify ways of improving our support for rule of law in fragile contexts by working with a stronger understanding of political dynamics. We look forward to hearing more about the main conclusions of the recently published research report as part of this project and the implications for our work. To kick off robust discussions on this important topic, we have assembled a panel of renowned experts with concrete experience in supporting the rule of law in very complex political settings. The discussion today will further add to our understanding of these important elements of building rule of law and supporting human rights. I welcome you again, and I look forward to the discussions today, and will now hand over to Assistant Secretary General Taye Brook-Zerehorn from the Department of Political Affairs for his opening remarks. Taye, the floor is yours, and thank you.
Thank you, Seema, and good morning. Good morning, all panelists. I'd like to start by thanking IPI and certainly UNDP and also the Folke Bernadotte Academy for this very timely event. We in the Department of Political Affairs, we are a key department. We are a department charged with supporting member states in efforts to prevent the outbreak, the deterioration, and also the recurrence of conflict. And as such, our work, the department's work, is linked inextricably with the rule of law. We have also a number of field missions that are mandated to provide support in areas ranging from police and security, justice and corrections, to constitution making, decentralization, electoral assistance, and strengthening parliaments, as well as addressing transitional organized crime and transitional justice. In all these areas, we see a two-way relationship between political processes and the rule of law. On the one hand, there are many political obstacles to the entrenchment of the rule of law. On the other, the rule of law can have immense consequences on political processes. This relationship will be the focus of my brief remarks here today. From Somalia to Libya, from Guinea-Bissau to Afghanistan, societies are hoping for a world free of fear, a world free of want, and a world where human rights are protected and promoted. When the guns fall silent, the United Nations is often one of the first organizations on the ground helping countries to start strengthening institutions. Member states count on the United Nations to quickly demonstrate the value of the rule of law and build trust in institutions that constrain power, resolve grievances, and strengthen security and enshrine inclusivity. The reasons are self-evident. It's mainly because failures in the rule of law are at the heart of the many crises we face today. Without the rule of law, institutions of the law, the Constitution itself, the courts, the police, the prisons, are frequently used as tools for political and personal gain. There is no security or accountability. Human rights abuses are committed with impunity. Injustice breeds discontent and worse, instability and violence. Conversely, we know that when it is effective, the rule of law constrains the abuse of power on the part of those who rule. It subjects their decisions to checks and balances and makes them accountable. The rule of law is often not convenient for politicians. With the rule of law, we can start to build public confidence in political settlements and restore trust in state institutions. We can support the implementation of peace accords and assist the conduct of legitimate electoral and constitutional processes. We can protect civilians and facilitate humanitarian assistance, as well as ensure law and order and also fight crime. The majority of our work takes place in complex and fluid contexts where member states are faced with a daunting array of challenges at the intersection between political processes and the rule of law. Let me cite a few examples. In Libya, there are many political challenges to the implementation of the rule of law, obviously. With no government control, institutions operate independently and most often according to the will of the armed group that is in control of a particular area. Indeed, the political polarization fueling the conflict in Libya has carried on to judges and other court officials. Furthermore, with no endorsement of a government by parliament, reforms are unlikely in any time in the near future. In these difficult circumstances, the United Nations and partners are taking modest steps to build trust in Libyan institutions by working to address the security, safety, and of the Libyan people at the national and local levels where entry points may be possible. A program of support to the peace agreement between the municipalities of Misrata and Tuareg is currently being financed by the UNDP and the UN mission on the ground, UNSMIL. It will support continued political dialogue between the two municipalities, as well as provide support to areas including reparations, restitution, and support to returnees, and to demining efforts. In Somalia, rule of law is also intrinsically tied to the main political processes. While there is a general agreement that Somalia is to be a federal republic, the overall political environment is still characterized by mistrust and a disposition not to share power with the federal government. To cite an example, early discussions on creating a model for justice institutions for the country produced options where states retain complete control over each aspect of the justice sector, including parallel constitutional courts and judicial service commissions. Clearly, such a dual justice model is not viable for a country with low human and capital resources. On the other hand, we have examples of how work in the areas of rule of law can receive political endorsement and start building trust in very difficult circumstances. For example, with the help of the UN and partners, for the first time in the history of Somalia, a recent consultative conference of ministers for internal security at both the federal and state levels agreed on a federal policing model. Moreover, the UN's joint rule of law program in Somalia is also increasing the access of justice through enabling mobile courts to reach remote areas, supporting the country to deploy police officers into areas beyond Mogadishu that have been recovered from Al-Shabaab, and facilitating crucial biometric registration for security services personnel. In Guinea-Bissau, conflicting interpretations of the Constitution on the delimitation of power between the President and the Prime Minister contributed to a seemingly unending political crisis that is deeply affecting the functioning of all the institutions of governance. The result has been a dismissal of 3 governments since the general elections in 2014 and a stalling of national reforms, including in the areas of justice, public administration, and security. And while we continue to provide support to combating drug trafficking and transitional organized crime, the broader political context in Guinea-Bissau remains fluid and unpredictable. Now, ladies and gentlemen, member states have placed hope, justifiably, in Sustainable Development Goal 16, which calls for the promotion of peaceful and inclusive societies for sustainable development, access to justice for all, and effective, accountable, and inclusive institutions at all levels. They believe that the rule of law is an enabler of peace and security, human rights, and development. We have a responsibility to help societies strengthen the rule of law. This is why this discussion here today is so important for us. I want to thank you again for inviting me to participate in this event. And I look forward to the discussions here today and also to share ideas and thoughts on how best we can find answers to the many probing and relevant questions suggested for discussion, notably on how effective rule of law promotes healthy and robust state-society relations. I thank you for your attention.
Great. Thank you so much for giving us such a great start to this morning, especially in your comments and examples on the ways in which rule of law and political processes is a two-way process. The rule of law supports political processes, and political processes support the rule of law. And with the rule of law, as we know, trust and confidence in political institutions rises, leading to a healthier state-society relations, which I think is a critical point and something worth emphasizing. We have an excellent panel for you this morning, although I'm sorry to say that UN Special Rapporteur Pablo de Greff, who was scheduled to be here, has taken ill and is unable to participate, but nevertheless, I think we have sufficient amount of expertise and knowledge represented by our remaining panelists to make this a very worthwhile discussion. And as I can see from the interest in the room, I think we're also going to be sure to have a good Q&A. So we have Dr. Richard Sannerholm, Rickard. We talked about this earlier. Head of Rule of Law at Folke Bernadotte Academy. Ms. Sarah Hussain, a barrister practicing in the Supreme Court of Bangladesh and honorary director of the Bangladesh Legal Aid and Service Trust. And Dr. Rachel Kleinfeld, Senior Associate, Democracy and Rule of Law Program at the Carnegie Endowment for International Peace. You should have full biographies in your handout, so I will skip the lengthy introductions that would be required to really do full justice to the many accomplishments of each of them. Our panelists have been asked to discuss the political challenges to the rule of law, exploring the ways and means of combining political engagement and technical expertise to establish effective and rights-based rule of law in the context of rising tensions in state-society relations and efforts to implement the Sustainable Development Goals. That, I recognize, is a tall order in the allotted 7 to 10 minutes. But we have a wealth of knowledge and experience in this room, and so, as I said, we hope to have a vigorous Q&A session before I invite Ms. Bahu's back to the podium for closing remarks. That's the program. So let's jump right in, shall we? Rickard, the floor is yours.
Thank you, Adam. Thanks to IPI for organizing this event, and to our partners in this project, together with UNDP, the team here in New York, and colleagues in the field, country offices and regional hubs that we met for the better part over a year, having a conversation on rule of law, politics, working and thinking politically smart around rule of law in fragile and complex settings. It's a good turnout today. It says light breakfast on the agenda. That can't be the sole attraction. Rule of law is receiving growing attention in development and peace building. I think the turnout here is one small indicator of that. It's also an agenda that has expanded from traditionally development towards peace building as well. And at the same time, there's a growing criticism mounting on how rule of law reform is being implemented. And that criticism has been, it's been around for quite some time, but it's growing in terms of a number of scholars and practitioners engaging in trying to reform how rule of law reform is being implemented. In parallel to this, there's a rich and vigorous discussion in an emerging community of thinking and working politically. Some of you may also recall or be aware of the Do and Development Differently streams of thinking as well. And this discussion, this community has a number of different and significant findings that can provide guidance to rule of law, which is, or rule of law reform, not a concept as such, rule of law reform that is, in a sense, at a crossroads. for being expanding, attracting a lot of attention, a lot of demands are being placed on what can be achieved with or through rule of law reform, and at the same time the mounting criticism. And this guidance that can be drawn from thinking or working politically is desperately needed, because the pursuit of rule of law in anywhere, but specifically in fragile and complex settings, is inherently the pursuit of a political goal. And that has to be said up front. And by political, I'm talking about power dynamics, power relationships, how power is being exercised, contested, how resources are being distributed, gender power dynamics, all of these instances of how we understand human interaction in different forms. And also the realization that sometimes rule of law has very little to do with law, really, but more to do with other things, such as behavior and attitudes and understandings and trusting in who should and who has the legitimacy to regulate human interaction and social conflict, as it were. Now, the political aspects are, and we've heard it this morning already, now being regularly emphasized by the United Nations in different forums. We saw that last year in the international reviews. It comes out really clearly in the Agenda 2030, particularly Goal 16, so the understanding of political blockages behind development and also in relation to peaceful societies. And together with UNDP, FBA started working on a project and to look into how rule of law reform, the agenda that UNDP carries, and the global rule of law program can become more politically in tune and aware when it comes to working in very challenging environments. And one outcome of that project was a report, and I'm not sure how many of you have time to read a 92-page report. Fortunately, there's a brief as well. You can find both of them in the back of the room, where we set out to look at why rule of law has only been marginally represented why politics is only marginally represented in rule of law reform, why this matters, and then looking into how politics can be or become part of the rule of law agenda of the UNDP. The main message of the report is that, and we've heard it this morning and in other forums as well, that development and peace building does not require a technical fix or can't be solved technically alone, but also requires a political course of action. But for a long time, rule of law reform has been hampered by a very supply-sided perspective, making reforms too technical and too formalistic. And also that implicit assumptions that technical neutrality can later spearhead or initiate substantive changes, that has prevailed for decades as well. And this assumption is also underpinned by a technical path dependence and domination of technical experts, lawyers and legal professionals, the rule of lawyers in a sense, in rule of law reform. Now, when I give this bleak narrative, it's important to really strongly emphasize that there are many exceptions to this narrative. Certainly, we look at UNDP practice, you see numerous exceptions. But these exceptions also tend to be on the level of the individual. That's what we found in our project. You have very many resourceful individuals within UNDP and other UN agencies, but very little in terms of institutional support and policies on how to make their work easy in terms of thinking and working politically in the sense of aligning it with national and local priorities and other smart strategies. What we suggest in the report and our conversation and collaboration with UNDP is to break with past practices that have worked poorly, has a poor track record in conflict and fragile settings, and to better utilize what works to document good examples and the experience that exists within the organization of the UN and UNDP specifically, and to maximize the potential that you have within the UN system when it comes to joint programs and bringing in politics. Two specific examples: the Global Focal Point for Police, Justice and Corrections is one. Another one is the Peace and Development Advisors, the joint program between UNDP and DPA that we see coming clearly in our conversations with both the UNDP staff and others in this field. The study identifies two interdependent levels where change must take place for the UN and UNDP when it comes to bringing politics into the agenda. One is the level of programming, where rule of law has become more responsive to needs, problems, and political processes and power relationships in complex transitions. There must be much more of a political analysis underpinning rule of law reform than it is to date, and a willingness to go beyond law in order to support law. The other is the level of organization, meaning the policies and bureaucratic practices of the UN and UNDP. And it's important to bear in mind when we talk about political economy analysis, there's something tempting to do a political economy analysis of UN agencies as well in order to see, well, how can we best support change? Because in order to include politics on the rule of law agenda, in order to work better and more effective in conflict and fragile states, it's not a technical fix that is required at the level of the UN, but rather a cultural, political, dynamic shift in the same way we argue for conflict and crisis settings. For the sake of time, and also to allow us to have an interactive Q&A later on, I'll concentrate in my closing on 4 broad recommendations that we left out in the brief and the report. Speaking specifically for UNDP in this regard, one is to make political analysis an integral part of programming. This came out clearly in the conversation we've had with numerous staff in the field and in different locations, that political economy analysis or political analysis, whatever you call it, rarely figures as a systematic way and underpins programming. Some say we don't have the luxury of doing this, we don't have the time to do this, or we don't have the competence to do it, or you do it and it's an expert coming in doing the analysis and then that expert leaves and you have the program staff doing the programming. We think that it should be more clearly stated as a responsibility of the UN leadership in the field to encourage linkages between the political and the technical, as it were, the programmatic part, to ensure that program staff can participate in political analysis to better inform the programming. We think, there's certainly evidence for this, that the joint program between DPA and UNDP, the Peace and Development Advisors, has the potential to bolster this and to strengthen that link between politics and programming in more ways than one. Second broad recommendation is to be more explicit about risks when it comes to engaging in conflict and fragile settings on behalf of the UNDP. UNDP should make responsible policy explicit in recognizing that no intervention because inopportune moments, the lack of information or overstretch is responsible and encouraged course of action. This also requires making explicit any unintended consequences of interventions and also an encouragement of UN leadership in the field to calculate the risk-taking and flexibility in programming, including halting and abandoning programmatic goals when called for. Third, in terms of broad recommendations, and this is the boring one really, but the important one, to turn individual competencies and strengths into institutional capacity. This is one of the striking evidences in our conversations with UNDP staff and UNDP over the years, not just this past year in this project. The level of competence and skill you have within the organization and other UN agencies as well, but that it tends to remain on the level of the individual, and more has to be done in order to do a systematic competence provision to make sure that there's sufficient feedback loops into informing new programming based on past practices, particularly when it comes to the political acumen being collated by individuals in the field in different settings. And there's a lot of this going on, and more has to be done to do it. But this is very organizational, time-consuming, and it's a long-term process, but it has to start and be strengthened. It has started, but it should be strengthened. Fourth and last, improve the link between, on the one hand, conflict prevention and rule of law programming. In our conversations with UNDP field staff and also others, but primarily UNDP field staff, it came out clearly when they work on a very sort of programmatic objectives, they encounter and meet and discuss with national counterparts of various capacities, and they often spot or detect or see signs that things are not going in the right direction, or early warning signals of various kinds. And they requested a way of feeding that back to the conflict prevention side of things, so a political branch away from the programming side, so that I could inform other parts of the UN system. And that this link or that feedback loop was not as strong, or when it was strong, it very much had to do, again, on the basis of individual, resourceful individuals pushing that through and not an institutional encouragement. Now, to paraphrase what Adam said later, I mean, what we're saying here now are these 4 broad recommendations, and there are more in the report. That's a tall order, obviously, and it's not something that change doesn't come easily for anyone. And it's not something that UN or UNDP can or even should do alone. This also requires frank discussions with donors, and member states, being clear and more specific on what they can realistically demand in certain type of settings and interventions. The encouragement of calculated risk-taking and more responsible courses of action when it's difficult to intervene or it's not an opportune moment to intervene. So I think I'll stop there. Thank you so much.
Great, Rickard. Thank you so much. Thank you. You know, it's striking to me. You started by saying the rule of law is reform is at a crossroads, and I think in this community there's a general sense that the UN itself is at a crossroads, and we've had many discussions in this room about potential reforms at the UN, and it's striking to me how many of your points are echoed in so many other topics that we've discussed, in especially in relation to peace operations, the primacy of politics, the sense that the responses can't just be technical or formalistic, the need to work better together. You mentioned joint programs, and I think we have an example of that here in the front row with DPA and UNDP working together. It's fantastic. And then of course the issue of prevention, the need to improve capacity around prevention. I think that really is sort of the zeitgeist right now in this community. And of course the key will be to put that into to implement and put it into practice. And so your concrete recommendations are very welcome. Thank you so much. So now I'll turn the floor over to Mr. Hussain for the view from Bangladesh.
Yes. Thank you very much. I'd like to start by thanking the organizers, of course, IPI, UNDP, and the Academy, for what I think is a really timely, really important discussion around the challenges and the opportunities that we have in terms of addressing the issues around political engagement and rule of law work. I'm going to be speaking from my location, which is as a practicing lawyer, but working with an organization of lawyers. I take Rikard's point that rule of law shouldn't be ruled by lawyers, but I think lawyers are kind of relevant and we shouldn't be thrown out with the bathwater. So the organization I work with in a pro bono capacity is called the Bangladesh Legal Aid and Services Trust. And I think its history is also something important for us to look at. Bangladesh is now in its 45th year of independence, but we spent approximately 20 years of our lives under military rule. And as we emerged from that, many of the lawyers who had been part of democratic movements and the struggles for restoration of democracy and accountability then organized themselves around institutionalized legal aid provision. That is what our organization does. I think that's an important lesson for emerging democracies, for fragile states, around how do you actually harness the power and the strength that resides in the legal profession? How do you develop it? I think some of our experiences are also instructive. So having started as a lawyers organization focused very much around the courts, around the traditional institutions of justice, we recognized very quickly that actually that simply isn't enough. You can't be effective only being located within the justice system, within the formal systems of justice, and you have to engage with the informal. So now we work very closely around advice provision, mediation, litigation, and strategic litigation and advocacy, along with capacity building. We also recognize that while lawyers are critical, they're not sufficient in themselves, and they can't actually do the outreach, they can't actually be present in the spaces where they're most needed. And so we started working with paralegals in the community and also working with community-based organizations around capacity building, around knowledge generation, not only around rights, which has often been our model of doing legal awareness work in many countries, is giving knowledge, imparting quite detailed knowledge around rights and remedies. But critically, what we found is actually it's crucial to impart knowledge around services and where these are actually available, because people need to get to people who can actually secure responses for them from the system. It's often not sufficient to know just what it is what your own rights are. Also, increasingly, I think we've become aware of where the threats are to understanding and developing a common position around protection of human rights. That the threats are both internal and external. While the state is the principal repository of the duties to ensure protection of rights, it's often a source of threat. How do you then develop and impart legal aid in a context where you're reliant on a state which can be authoritarian, which can be repressive, which can be the source and is the source of violation of rights? You need to have independent bodies, independent actors providing a check and balance. What happens in the context where the threat is not only from the state, but from strong private actors, from extremist organizations, which we're increasingly increasingly seeing across the world. What kinds of protections do we have in working around legal aid, around protection of rights against such organizations? How do you develop a culture of resilience and resistance to such organized political attacks on the entire notion of human rights and justice? How do you also engage with corporate power? I'm going to talk about public-private partnerships, about the need to engage corporates in the process of protection of rights, delivery of justice. But I think we also need to recognize that corporate power can be a threat in this area. And where corporate power is linked with untrammeled political power, unchecked political power, it's even more important to ensure, again, that there are independent, strong voices calling them out and being able to, again, provide a focus of resistance and response. In terms of, I think, the need for political engagement in the rule of law arena, I think Ricard has said all of that. I don't need to repeat that. What I would like to stress, though, I think, is that we need to really, in doing this work, have an understanding of how embedded or not notions of human rights are, and how possible the scope is for people to actually seek justice. Some of our research from Bangladesh shows, for example, when we were activating and setting up the National Human Rights Commission in Bangladesh some years ago, an initial perception survey showed that less than 40% of people had any understanding of what the notion of human rights meant at all in the first place. So that means really not for us not taking for granted many of our common frames of reference. And that doesn't mean throwing out human rights. It means breaking it down to understandable, comprehensible terms. It means saying, do you understand that the police do not have a right to beat you up whenever and however they feel like it? That actually can elicit quite disturbing responses, as we've seen in our context, but those are the questions that need to be asked. Secondly, we need to be aware when we're focusing on the justice institutions, and whether informal or formal, understanding actually, is there a reality of people being able to seek justice? Again, we have interesting statistics from Bangladesh showing that, from WHO studies, showing that less than 2% of women who actually experience violence ever seek any kind of response from any institution whatsoever. Now, that means that we need to turn around the kind of response we're going to have. Rather than saying, let's put tons of lawyers into the courts, let's ramp up the entire formal judicial system, which we should also do. There are good arguments for doing that, but we also need to look at the fact that we need to get people into those systems in the first place. We need to be able to have them deal with the barriers that exist that mean that they don't want to come out. What are those barriers? There are barriers around, certainly there are barriers around the usual ones that we know that are amenable to technical fixes. Barriers around costs, barriers around distance, barriers around delays in the system. We can fix that by providing free legal aid. We can fix that by providing costs for transportation to the courts. And we can fix that through trying to deal with case management. What we can't deal with technical fixes is how do you deal with stigma? How do you deal with reprisals? How do you deal with the fear that you're going to be cut down or your family are going to be ostracized for simply trying to seek justice? That requires culture change. That requires a significant political engagement. That means taking on powerful forces. And that means that we have to program that into the work that we do. I was asked to look at concrete examples. So let me give a few examples. We always start, I find, as human rights lawyers with the disasters and the mistakes and the things that don't work and the things that we're never going to overcome. So I think I'd like to start somewhere different today. Let me start with some of the successful engagements and where we've actually experienced that programmatic interventions around strengthening justice delivery have worked. And I'll start, since we're being hosted by UNDP, by an interesting example and a positive example, I think, of UNDP's work on the ground. This is its work with activating village courts. It's a Bangladesh-specific example. It's now in it's just starting out its second phase. This is a program that is, I think, in some ways very counterintuitive and quite hard for us to grasp as lawyers. It deals with having elected officials being on a panel of judges in a village court dealing with petty disputes. Every lawyer in the room, I'm sure, is throwing up their hands saying, how can that be possible? It is a complete, total negation of the basic principle of separation of powers. It simply can't happen. We really don't want to have that happening anywhere else, whatever you guys do out there in Bangladesh. But it works. Why does it work? Because it builds on traditional understandings of dispute resolution. It builds on the Shalish model, the mediation, which is embedded in rural communities and
all communities across the country and indeed across the region in South Asia. But what it then does is it doesn't package into the system the problems with the traditional dispute resolution process. It gives you a structured format. It gives you individual identified persons who will be based, because of their location as elected officials, who should, theoretically at least, have accountability to the community as the justice providers. And it builds in women's representation into the panel of judges, and it is only allowed to deal with petty dispute resolution, doesn't deal with domestic violence, doesn't deal with any forms of violence, and so on, doesn't deal with offenses against the person. It helps to siphon out cases from the formal system where they can be dealt with by the village courts. It helps to move cases that shouldn't be before the village courts into the system. And it works. It's near, it's close to people, it feels like part of their lives. It doesn't require a 5-hour trek to the city and paying all kinds of officials along the way. It's very transparent, everything's happening in front of you. It has embedded problems because there are elected officials in a situation of very partisan politics, in a situation where the law is used often as a weapon of political control, where false cases can be used to harass and are used to harass and intimidate the political opposition. Yes, there are many built-in problems, but those are precisely the problems one has to understand and engage with, but this is a successful example. One other one, give me a sense of time. One other example I'd like to share is a German and British DFID and GIZ supported project, again in Bangladesh, dealing with the issue of overcrowding in prisons. Again, this deals with exactly, I think, these new understandings of how can the law best be delivered, not always by lawyers, but having lawyers built into the system. Paralegals go into prisons with the support of the Ministry of Home Affairs, the Ministry of Law, and provide legal advice to indigent prisoners who've been long overstayers, i.e. they've been in jail for years without any kind of representation, grossly, unfairly denying all of their rights to speedy trial, fair trial, and so on. And the second limb of this project, this intervention, is paralegals on the one hand, and secondly, building coordination and communication within the system. So setting up case coordination committees, which bring together every single relevant body at a district level involved with criminal justice, the district magistrate, the chief of police, the superintendent of the prisons, the Bar Association president, and very interestingly, shifting dynamics of power through doing rather than through speaking, having paralegals, young, new graduates, not with legal training, but supervised by lawyers, being the ones who present cases to the case coordination committee, take the decisions, go back into prisons, appear before the courts, and make the system move. Again, it's working, it's spreading across the country, it's got buy-in from the government, it's got public-private partnership embedded, just like the Village Courts project, having NGOs helping to deliver through paralegals the services. And again, why are these public-private partnerships so important? They're important because they protect you against some of the common problems that we face. They protect you against the risk of corruption and the perception that corruption will be there. They ensure that fast startups are possible. You're not waiting for massive bureaucratic developments. You're not waiting for new positions to be created by ministries, which are going to take years to identify, years to budget. You can get a startup going. You can get a successful process on the way. You can get the buy-in, and then you can expand and develop. I'll wrap up with two not so happy examples, I think, which should give us some guidance of where we don't want to go. Some older examples, which will remind us of some of the problems. One is an old World Bank project around judicial reform, just looking at many examples from across the world, many from Latin America as well, Africa and other parts of Asia, which looked at lots of computers, lots of infrastructure, and which in Bangladesh we had a wonderful symbolic result of this, which was lots of concrete structures built around large trees in our Supreme Court, going round and round in circles and leading nowhere. A lot of money was spent on that, not very many results. That's clear, I think, to everybody that that's not the way to go. Other more problematic things are massive police reform projects. Again, in a context of where the law is used to abuse power, where, again, it's used to intimidate, police reform projects which put lots of infrastructure, lots of weaponry, lots of untrammeled power and capacity building without any commitment to change in the hands of law enforcing authorities can actually risk having the unaccountable becoming even more unaccountable. So finally, where should we go? Just some recommendations for how to go forward. I think the things to look at are how do we build the partnerships? What kinds of partnerships on the ground can be effective? How do you build in civil society organizations that have a track record of working around justice, whether they're at absolutely community level, national level, or otherwise? Which agencies, which ministries, again, have shown a track record in terms of cooperation, in terms of willingness to engage? How do you envisage how do you pick out the examples, like I think with the prison project that I talked about, or the village court project, which don't deliver the earth, but do make it possible to see some kinds of results, which do make you feel that it's possible to build on that, which do allow for some reflection on where the challenges and the problems are and how do you address them? And finally, how do you build in communities beyond the practitioners, beyond the experts, to help deliver change as broadly as possible? I'd like to end by, I think, just paying tribute to, all of you will be aware, I think most of you certainly, about the kinds of developments we faced in Bangladesh over the last 2 years with serial killings claimed by extremist groups of exactly the kind of people who make Bangladesh the kind of poster country, I think, for development change that it has been. Secular writers, bloggers, human rights activists, activists for LGBT rights, who've been mown down, killed in serial killings. I'd like to pay tribute to them, but I'd also like to add a cautionary note that as we've seen in the last couple of months, we've seen those accused of being involved in these killings not brought to trial through fair processes, through courts, but again killed themselves in serial extrajudicial execution. So the threat of impunity, which is one we live with in many of our countries, is also something that has to be addressed as we look at the developmental challenges in front of us in terms of delivering rule of law. Thank you.
Thank you. Thank you so much, giving us the view of practicing lawyers. And I take very much this notion that you can't just be effective if you only stay within the formal sector, that you need to engage with the informal sector in the communities and bring in civil society. And I think your examples really provide a great some great examples, concrete examples of that. And thank you for reminding us that while, of course, politics is key, we can't forget the contributions of the technical elements to help inclusion and strengthening the role. And of course, lawyers such as yourself have an important role to play. And I think you exemplify that yourself. And I was struck by you emphasize the importance of checks and balances and the importance of independent voices, and I get the strong impression that you are indeed one of those very independent voices, and so I thank you very much for your contributions. We'll move on to Rachel. Thank you.
Well, thank you. It's an honor to be here. It's an honor to be with my fellow panelists. In a think tank, you have the luxury of sitting back and thinking. Some of us don't have that luxury and have to be actually on the ground working, and so it's just a thrill to be here with you. It was also a thrill, frankly, to start off with Seema's remarks. I feel like those of us working in this field for a while, it's been about 2 decades since I started in this field, and at first it was this pushing a rock uphill. It's trying to tell people how political the rule of law was, that the core idea of the rule of law challenged the notion of rulers who could get away with anything, who had impunity, who were above the law. And having that thrown back at us, and no, it's technical. We need to deliver computers, we need to build buildings, we need to deliver, can't you see that the police have no cars? How can they have justice if there's no cars? So we're going to give them cars. And those of us who are saying, well, there's a reason they have no cars. There's something a little deeper. Let's dig a little deeper. And to move from that to a room full of people who are here to talk about politics, to hear the Folke Bernadotte Academy's fantastic report, which I strongly recommend people read, that gets in depth into how you make the changes that we need to look at things politically, and to just see how far our field has come, I think is a huge pat on the back to everyone in the room, and is really exciting. It doesn't mean that the change has happened. I think there's a lot more talk than change on the ground. But we need to think it before we can do it, and I think we're getting there. So that's very exciting. I have a paper that is much shorter than the Folke Bernadotte Academy's paper, and I thought that I would bring enough for some of the people in the room, so I brought 6 copies. I sort of underestimated, but anyhow, they're in the back, and if anyone's interested, it's on Bihar and the problem of Maoism and how they fought Maoism with politics in Bihar. And it really gets in depth into what that looks like on the ground. These remarks will be much, much broader. But I wanted to start with some work that Boo Rothstein has done in Europe, that the WDR 2011 said, that my own work has said. I'm working right now on a book of countries that had faced extreme violence and came out of that extreme violence, and how they did that and what led them into the violence. And so my remarks today are coming from that forthcoming book. And one of the things that we've all found is that this change takes a lot of time. It takes 20 to 50 years to really change a society on issues of rule of law and these deep political issues. And as that change happens, it doesn't move in a straight line. You don't get a country going from bad to good on the rule of law. What you get is opposition pushing back at every stage. And so the path starts looking like this. It's a non-linear path with progress in one direction and pushback in the other and progress again. And that's the very nature of politics. The opposition organizes against the reform and pushes back. So let me start with an example of this, one that's very close to home for me and perhaps for a few of you, to just explain this in a context and in a story, which is the United States Civil War. So 150 years ago, the US was a post-conflict society. We'd fought a gigantic civil war, and there was political violence happening all through the South. So you had night riders, you had mobs of people going around killing for electoral violence reasons. So before our elections, you would have 1,000 people killed in Louisiana, 2,000 people killed in Kansas to change the course of elections, which sounds quite familiar. And as those mob killings were taking place, they were taking place against certain people, right? It wasn't just there was no rule of law. It happened to be that certain people were being killed, certain people who wanted to vote for the wrong party. And other people who wanted the vote to go for the other party were the ones doing the killing. So right away, you get some politics involved. Were the courts prosecuting those people doing the killing? No. There was a court system. There were lawyers. They were well established. America had a very deep rule of law in the South at that point. Were they doing anything? No. By the 1890s, 25 years after the Civil War, so now we're talking a quarter century later, you have a lynching every 3 days in the US South. Every 3 days, an extrajudicial killing in a country that has a perfectly good system of justice. Were those lynchers being brought to court? No, in fact, they were publishing postcards of lynchings. People knew exactly who was responsible. It was often sheriffs who were opening the doors to the perfectly good jails and allowing lynch mobs in. It was often elected officials who were at the front of the lynch mobs because it would help their electoral chances in the next election. Right? This is not a technical problem of a lack of equipment or a lack of gasoline for your cars in the 1890s, probably not a lot of cars, a lack of shoes for your horses. That was not the problem. This was a deeply political problem that had to do with a group of people who wanted to maintain privilege and impunity for white people and didn't want African Americans to have the right to vote, didn't want African Americans to have the right to the same kinds of powers as the white powers that be. And the rule of law problem in America is still not solved by any means. This particular problem only got better as people started to organize and fight against this kind of action. And one of the things I find in this book is that in every case where countries went from a great deal of violence to less violence, you had a joint effort, and it was a joint effort that's best described by the mayor of Palermo in Sicily. When he was fighting the mob, he said state and society are like two wheels on a cart, and they have to move in tandem for change to happen. If only one of the wheels is moving, the cart just goes around and around in circles. And what you saw in these countries that escaped vast amounts of violence was that society organized and said, enough, we're not going to allow this to happen anymore. And they elected officials who shared that viewpoint and were willing to make change together. In America, it took until the 1960s, really, until President Johnson, before you got real change in the South. You had a frozen war there for many, many years. So what does that mean for UNDP programming? What it means is that we're looking at change that takes between 20 and 50 years. That's what I've found. That's what the WDR 2011 found. That's what Boo Rothstein has found. 20 to 50 years. But our programming happens in 9-month intervals, 5-year intervals, if you're really, really lucky, right? And the question that we've been asking ourselves as programmers is, how can we build the rule of law? And I would posit it's the wrong question. What we need to be asking ourselves is, how can my 9-month intervention leverage 20 to 50 year change? What can I do in 9 months, 1 year, 2 years to leverage and catalyze change on the ground that will fight this back and forth, opposition fighting back, this kind of nonlinear change for 20 to 50 years? And as soon as you start looking at it that way, you realize, well, gosh, providing computers is probably not the answer. Providing police cars is probably not the answer. What I need to do is find some people on the ground who are going to fight this fight for much, much longer than me. I need to find people like this one and help that change happen, right? And so that kind of thinking catalyzes a whole new type of action, right? You're looking at coalition building on the ground. You're looking at local leadership on the ground. You're looking at, are these people stronger after we leave? Are these coalitions stronger after we leave? Have they become dependent on our aid, or do they have ways of finding money independently? Do they have a place to be housed, or do they have meetings that are hither, thither, and not very organized? What kind of capacity do these people have to keep this program going when we leave? And if we start programming with that kind of thought in mind, it changes the entire way we both do the programming, but also the way we measure our results. And this is incredibly important, because as long as programmers are incentivized to show results in 9 months and measure results based on their outputs, it's going to be really hard to do that kind of catalytic change with people on the ground. And let me give you another little story from the book, which was looking, among other states, at Georgia. So the Republic of Georgia in the early 90s was riven by another civil war. Incredibly high levels of violence. You had refugee flows coming in from breakaway statelets that Russia had sort of catalyzed to break away. You had 2 militias fighting one another throughout the country, committing horrible war crimes against the people in the country. I was interviewing lots of people in the west of the country where houses were set on fire, mass rapes, people fleeing across the borders. You had gangs in the cities that were setting up roadblocks, and just anybody who was walking in and out of the city would have to pay money, would have to do whatever the gangs were saying. And this was the early 90s in Georgia. And 2 of those militias invited back President Shevardnadze to be basically a figurehead president. And they said, look, nobody's going to give us any money, but if you're the president, the international community might try to help Georgia, and by the way, we've got all the guns. And so there's some incredible interviews I did where people would say, look, President Shevardnadze was there rubber stamping various orders to steal private property, to turn things over to these militias, and he had to stamp them all because everyone knew there were guns in the building. And meanwhile, the aid started flowing in. But President Shevardnadze was a very smart guy. And one of the things he started doing was making side deals with the underlings of these militias. And he gradually built up enough state power that he could manage to arrest these militias. Various things happened. There was an assassination attempt and so on. And he managed to quell that violence. And one of the main ways that he quelled the violence was through corruption. He gave everyone a piece of the pie. And he was very conscious that that's what he was doing. And so he gave one warlord the police, and he gave the other warlord the state security services. He gave some of the nomenclatura the energy ministry, and he gave someone else the education ministry. And over time, so many people had a cut of the state that they didn't want to overthrow President Shevardnadze. They wanted to keep him in power. The price of that peace, and he did bring peace compared to what had been in the early 90s, the price of that peace was a state that barely functioned. The police were corrupt and brutal. The security services were running a smuggling ring. There were literally shootouts between those 2 groups in the middle of the capital city, but they weren't killing other people, just each other, as they fought over smuggling routes and so on. And the problem with this situation became really apparent. You couldn't build a state that had this level of corruption in it. And a man named David Tusupashvili, who'd been the general counsel to the president, he was his legal advisor, he went to the president, he said, look, you've done wonderful things, President Shevardnadze, but we really need to change this corruption. The state was built on this corruption. It brought us peace, but it's not working anymore. It's been a decade, and the state's falling apart. And USAID actually, when David gave up and just thought nothing's going to happen, nothing's going to change, USAID let him run an anti-corruption program. And so David ran USAID's anti-corruption program, and he drafted all sorts of plans to fight corruption. He drafted a speech for Shevardnadze to give where he would go to his people and say, I'm so sorry, my people, I've failed you. I brought peace, but now the state has fallen apart. Now we need to fight the corruption. Give me another chance. It was this very heartfelt speech. And of course, Shevardnadze didn't give it. He was too scared that the war would break out again if he changed the situation. And so USAID ended the project after 2 years, and it was a huge failure. Georgia was still one of the most corrupt countries on the planet, and everyone involved with that project was rated badly. But expand the lens a little bit. David Saakashvili became one of the leaders of the Georgia Young Lawyers Association. He and his wife, Tina, as the heads of the Georgia Young Lawyers Association, were key to the Rose Revolution that overthrew that government, and they played a huge role in drafting the anti-corruption plans that the Rose Revolution government used that actually did fight petty corruption in Georgia to an enormous extent. There are still problems, but the petty corruption really did go away, largely based on the work that David had done and had thought about during those 2 years. Later on, as President Saakashvili became more repressive, David and his wife went into opposition. They formed the biggest opposition party. And as the biggest opposition party, they fought for human rights. They fought for liberal rules. They fought against a lot of the more repressive measures that the government was doing. And David eventually became the Speaker of Parliament. And he's in that role right now, and his wife is running the opposition party. And they are two of the loudest voices for real anti-corruption reform, for real human rights in that country. So was the USAID program a failure? Well, if you look at it from the building capacity, from helping an individual who needed a pivot in his career get that pivot and be able to have some space to think, I would argue that was a gigantic success. Those are the people, that party, those individuals, the people around them with the Georgia Young Lawyers Association, those are the people that are the core of civic society in Georgia that are going to push for 20 to 50 years for things that we all care about in the rule of law. And those are the people that we need to support. And so if we're going to start supporting them, we need to change the way we do our programming. And so I'll end with just an example of that in Afghanistan. In Afghanistan, there was a network building program that was disguised as an education program. The goal was to educate 18 mid-level executives. And so they went through an education program. But the real goal of the program, it was run by York University, the real goal was to create a network of change agents. And so as those 18 individuals were put back into government, they formed an alumni group. They had meetings, they would have lunches, they would go for coffee, they would meet one another, and they all knew after a year and a half in this education program that they cared about reform, that these were the people who wanted change. And they met and they tried to make change. And that's the kind of thinking that I think we need to start bringing to our rule of law programs so that we move from thinking politically to working politically. And with that, I think I'll close. Thank you so much.
Great. Thank you so much for both the analysis and the great storytelling, especially making very concrete this notion that the rule of law reform is not a linear process, that there's ups and downs and progress and pushback, and that is indeed politics. And it's also striking to me that to think that rule of law, it's not something that you just sort of arrive at and then you're done, right? It's a continual, it's a constant political process that even continues today in the United States. And this is really something that's universal. It's not something that's particular to one situation or another. And that means we need to take the long-term view. As I say, real reform takes 20 to 50 years, and the key is building local coalition partners, coalition building. And that's very instructive. I think I've kind of almost in this panel sort of ceded my whole role as a timekeeper, but I think I was so engrossed by the participation, by the presentations that I just wanted everyone to keep speaking because it was really useful. But we still have plenty of time for Q&A. We've got a good 45 minutes left for Q&A. So the floor is open, and I see one hand shoot right up in the back there. We can start there. We'll take a few questions and then come back to the panel.
Thank you so much, and good afternoon, colleagues. My name is Leonichenko Sergey. I'm from the mission of the Russian Federation. And since we are discussing the political dimension of the rule of law, my first question would be, since we are also discussing the UNDP possible role and the role of the United Nations in such sort of things, Basically, how would it go along with Article 2.7 of the UN Charter saying that UN cannot intervene in the affairs essentially within domestic jurisdiction of the state? And before you answer this question, I would say that this notion is probably there for a reason, because I'm very grateful basically for the examples given from Bangladesh practice, because the reason for success there was, first of all, taking into consideration the local specificities, including traditional specificities, and also working closely with local government or just the government of the state. And we have seen, of course, many examples which are not so successful. And in our view, we see a different reason, not because a political element was lacking in the rule of law efforts, but quite to the contrary. The reason for failure was that local specificities of the state were not taken into consideration to the extent necessary. I speak, of course, about such specificities as historical, legal, political, cultural. Every state is different, and it's entitled to the rule of law system which suits all these specificities. If we try just to change the state overnight, it usually fails. And I also like this example of the cart where all the wheels should go in at the same speed, because otherwise we'll be going in circles. And I would just give an example of so-called color revolutions or spring revolutions, where the society was stimulated externally for change, but the state was not ready for a change, or maybe the state was not ready for this sort of change because there was an attempt to build a West-type society in a society which is not West-type by its nature. And we all know to what consequences it led. Some of the states even now struggle with chaos, lawlessness, and we can hardly say that it's a big gain for peoples of that state. So, and also, since I was very intimately involved in the negotiation of the Goal 16, I can tell you that rule of law, it's not even in the Goal 16, it's in the target. But initially it was to be in the Goal 16. The reason why it is not there, because many delegations were cautious that the rule of law will be politicized and used as a political tool. And that is why it was removed, and it is now a very, very general target on the rule of law. And basically the states which were concerned with the rule of law being politicized were the state who would be probably the object of the assistance, meaning that they don't want that sort of assistance. They regard it as a useful tool, but first and foremost, the technical tool of technical assistance, which does not mean only police cars or fuel for these cars or computers. What I mean is that if we want to render this technical assistance more effectively, we need to understand the state we are working in, and we constantly call upon UN agencies to study the culture, the history, the traditions of the state, and the examples of success of such efforts prove that we are right in this direction, and so are the examples of failure. So basically, that'll be all.
Thank you. Yeah, right over here. Thank you for, please, if we can, try to frame your interventions in the form of a question so we can have a good back and forth. Thank you very much.
I will definitely do that. My name is Mavic Cabrera Baleza from the Global Network of Women Peace Builders. I'd like to thank UNDP, IPI, and Folke Bernadotte Academy for organizing this important conversation. By the way, we're also a partner of FBA, Folke Bernadotte Academy, in our work on the implementation of Resolution 1325 on women, peace, and security. So my question to the panelists is, how is gender integrated in your work on the rule of law? And specifically, what are women's organizations or women's civil society's role in that work? The second question is, in some countries, there are two sets of laws, statutory laws and customary laws. And many times, these two sets of laws are contradicting each other, particularly in the area of women's political participation or women's role in governance. And finally, I just would like to express my appreciation for the point raised by Ms. Hossein and Ms. Kleinfeld, that how do we really get beyond the community of experts and legal practitioners? And how do we build local capacities? Because the local communities are the ones who should benefit first and foremost in the observance and strict adherence to the rule of law. Thank you.
Great, thank you so much. Yes, here in the fourth row.
Thank you. Martin Grammatic of Hill Innovating Justice. Thank you very much for the great remarks. I want to ask the panel, what is your view on the idea of using competition and innovation as a tool for promoting rule of law? Mr. Hussein said only 2% of victims of gender-based violence went to courts. And we do a lot of justice needs study, and we usually find that not more than 5-6% of people with serious and difficult to resolve problems go to courts. And these are studies in low-income, middle-income, high-income countries. So the traditional approach is let's build courts, let's provide more police, and all these problems will be resolved there. But this is a great political dependence, isn't it, to put all these problems there. And as you said, there are other mechanisms which can create some sort of competition between the different providers, and in that way create less political dependencies and more access to justice for the people. Thanks.
I think these questions all go together quite well. You mind if we take maybe one or two more before we come back to the panel? I think that's good. Yes, here in the front row, here, and then we'll speak.
Okay, thank you. Thanks a lot. Very interesting. Thank you very much. Hani Megali from NYU Center on International Cooperation. You know, the key, I think you all touched upon it, but you didn't quite say it, is political will if we're talking about obstacles. And my question is really, how do you massage the political will to get the cooperation, to get the progress? You know, often if you're programming and there's no political will, you're banging your heads against the wall, and sometimes it's actually better to say we won't engage because there's no political will. But it's often very difficult to actually say that because we're all geared to let's engage because engagement will bring about change. But we go back, and Rachel, you touched upon it a little bit in terms of part of it is identifying individuals and working with them, and they will bring about maybe that change. But what processes are there that will help massage the political will and bring about that progress? Thank you.
I'm Javier Hernandez from the Office of the High Commissioner for Human Rights. Hani and I are former colleagues, so I maybe piggyback on his question. How would human rights be a useful framework for what Ricard mentioned, but all panelists also touched on specifying risk and drawing lines for withholding or abandoning program support? How are the red lines in human rights that are not only International Criminal Court list of horrendous crimes against humanity, that are politically useful for promoting human rights, but also establishing red lines and stopping programmatic work?
Great, thank you. That's quite a bit on the table. So I think we'll come back to the panel, and then we'll have one more another round of Q&A. Ricard, we'll start with you.
Sure. So thank you so much for the question so far. I think on the first question/comment, certainly not advocated in terms of interference in that sense. And we're really on the same line when it comes to engaging with countries in terms of specificities. That's really what working, thinking, and politically smart is all about. I think we really heard good examples from Bangladesh and Kleinfeld's description as well from Georgia and elsewhere, that this is really the proper way to go. And it's about aligning what you do with national reform priorities. But there's a hitch here, coming back to the human rights issue, and I get to that shortly. Because this also has to do with political will, of course. I mean, what do you do if there's no political will? Can you in some way massage it or promote it or support it? Of course you can, and perhaps you should in many ways as well. In some places it's just utterly difficult, and then what to do then? Well, perhaps wait. is the best strategy. But I think what we heard as well, the coalition building, I think is key in finding different smart strategic ways of building coalition, encouraging really where the rule of law hurts the most, encouraging coalition building with civil society actors, change leaders in society, in different stratas of society, together with state institutions or non-state institutions in order to encourage change. I think that's a good step if there's no proper political will to start building on. And I think in that sense also comes human rights into the picture. Certainly as a red line in a very clear respect, but as a central role also of ensuring that the state remains committed to the commitments they have made on an international level. And that could be one entry point, but it's highly political and rarely technical, and a very difficult one, but it could be one entry point in terms of lacking political will. On the gender aspect, that's key and central. I think you can't understand politics, you can't understand the political obstacles or the different pushbacks you get for reforms unless you understand the gender dynamics in countries as well. And this is properly and clearly documented by now, the link between also gender and domestic violence in relation to violence generally in societies. So that I see that as a key part in the discussion we're having now. We devote a bit of time on this in the report, specifically looking at sort of feminist institutional reform or gender justice reform, and the lessons that have been learned by those who work in those areas or those sort of sub areas within rule of law that have from the start encountered the political obstacles that Rachel said, tried to raise 20 years ago, because it's been an uphill battle from the start trying to raise awareness around gender and gender justice issues. And because of that, there's a lot of good lessons learned of how to be more strategic, building coalitions and alliances, finding different ways of attacking a problem, not from a technical standpoint, but from a sort of plurality of perspectives. And there's much to learn from that specific field that is key to the rule of law field generally. So in that sense, as a key centerpiece in what we are discussing, and sort of taking this forward as well. So thanks.
I think the issues around non-interference perhaps might be a little bit overstated, because of course all of our states are signatories and parties to all of the human rights conventions. I don't think we can say anymore that we're not party to those. I don't think we can say that we don't believe in universal human rights, and I'm sure the speaker wasn't intending to say that. And I think the successes of the Bangladesh examples are not only that they laid on to traditions, but they reformed and reworked on that basis and on an understanding of universal standards, and critically incorporating gender equality as a fundamental principle. I would not say gender equality is part of the tradition of Bangladesh. I don't think I'm as wearing those kinds of spectacles most of the time. But that's something that has to be built in, that we have to build consensus around, and we can't shy away from that. Thank you very much for the question around person laws. I think that is a really crucial discussion, particularly as we're addressing extremism and seeing that as a real threat. And I think we are seeing too many states moving back, on the one hand saying, yes, we'll deal with the extremists with counter-violence, we'll use counter-terror tactics and all of that, but we'll actually accept implicitly their basic agendas, which is about inequality and indiscrimination. We've actually heard things like women's organizations being told, until you're on the streets with sticks like the mullahs, we don't want to hear what you have to say about personal law reform. That, I think, is an unacceptable position. And so these things have to be engaged. But how do you engage it? Perhaps like the kinds of examples that Rachel was saying, that you don't necessarily engage full frontal head-on, saying we're going to do personal law reform 101 starting now. You can say we can do it around looking at the issues. Child marriage is a massive international agenda point right now. You can address child marriage through many different entry points, which are likely to be more effective than just, of course, you need to make sure the legal framework is in place. But marriage busting prosecutions are not the only way to go. Stipends, all kinds of other incentives that give girls alternatives to child marriage, more importantly, give their families real alternatives to the insecurity that many of them face, are also ways to go and where women need to be involved. Another, I think, very important way to go is around building the kinds of experience we've had of having women's organizations really involved on the ground in delivering justice services. So giving legal services together with, for example, health services, where again we find counterintuitively that women will come more easily to get health services than they will to get legal services. You can provide legal services on the back of health, deal with protection against violence through that. Political will, yeah, you absolutely. I was trying to talk around it and be diplomatic in the interests of many of those in the room. But that's absolutely right. I don't think we can walk away. I think you're right. You have to wait with some examples. But you can't just use the time while you wait to twiddle your thumbs. You have to build strength in opposition. And I think you have to keep speaking out. And I think that's another thing we haven't talked about today, which is, of course, about shrinking civil society space. Very much a reality. The organizations many of us are working through are precisely organizations that still remain, despite all our nationalist drum beating, dependent on foreign resources. I don't think it's going to change in the next 15 years we have to achieve the SDGs. We're going to perhaps become more reliant on private sources of funding. Now, that is beneficial because at least for private sources of funding, instead of big barriers being laid down, there are red carpets often. So we need to think about how to work with that and how to change. And finally, in terms of the red lines question, I think, again, a very important question. Here also we see that sometimes when we're looking at indicators and monitoring and tracking, we're tracking the good, positive, easier things. We're not willing to put into the indicators, as I said in my closing remarks, while you're looking at, yes, positive investigations have started, prosecutions have started, we're not marking anyone down for the extrajudicial killings. We're not even tracking them. We're not marking anyone down on the torture. Where we do the markdowns, it's in a dusty room in Geneva that no one's paying much attention to, which is when the treaty bodies are doing their monitoring. There's a whole big, massive discussions with microphones and mics and television cameras around the development agenda, which unfortunately doesn't happen with the Human Rights Committee reporting, with the Economic and Social Rights Committee reporting. So how do we bring those two processes together?
Terrific answers already. It's always hard to go third. But it was a terrific group of questions, and I'm going to sort of try to bring them together. It was wonderful to hear Russia is where I started my career in the early 90s, and working right above the biggest mafia casino in St. Petersburg at the time. And so the sense of rule of law issues in Russia has always been very deep. And I think the speaker's quite right that one needs to go deep into an understanding of a state in order to deal with the rule of law. And that's from a cultural perspective, it's from a political perspective, it's from a deep understanding of how one makes change within any society. And ultimately, that's what we're talking about. And I would say that the people who know best how to make change within a society are the people within that society. And so from a human rights perspective, but also just from a practical perspective, making sure that the societies stand up to the treaty obligations that they've already signed up to on open organization, on openness of speech, freedom of speech, on protections, that's essential. And so that gets to the closing space set of issues of how is the closing space for civil society, the closing space for organizing, the closing space for speaking freely, how is that affecting the ability of local people to make change within their own cultures and societies? I would say for those of us who are not local, one way to think about the problem would be to divvy it up into three baskets. And when I try to think about making change, that's how I think about it. You've got your political basket, or your political lever, maybe is a better way to say it. You're moving a rock, you've got your political lever, you've got your legal lever. There's ways to make change through the laws, through the courts, and you've got your social or cultural lever. And when the political will is blocked over here, you can still try with these other levers to make deeper change in society. So if I think about the LGBTQ fight in America for many years, there was not much political will to do much about this. Some groups fought through the laws. They tried to legalize marriage. They tried to legalize rights and so on and so forth. Other groups fought through cultural mechanisms. They put gay people on TV. They had pride parades. They did all sorts of things that changed how regular people felt and thought about these other people within our community. And ultimately, I would say it was probably those cultural efforts that had the greatest effect on ultimately the politics. The legal efforts played a huge role too, but the legal efforts were also on the backs of the cultural efforts. And so I would say for those of us who feel like we're hitting our heads against a brick wall politically because there's no political will, and you put your finger on the, that's the red button there that we're all trying to avoid saying from up here. When there's no political will, you can still work on the other agenda elements, and those are not soft ways of working, they're very hard ways of working. But I think best for outsiders to work with and through locals. That's the way that you're going to make the greatest and deepest change. For gender integration, what does that mean? I'm so glad that you brought up the issue of gender. When I was working in Ghana, for instance, so Ghana has laws on gender equality. Ghana has political will for some gender equality. It's patriarchal, but there's still a desire to have a fairly equal society. But if you go into the north of Ghana, it's very poor, it's very rural. There is not a lot of gender equality in practice. And there, when I was working with an NGO that was there, what it took was one woman who was being beaten by her husband to leave. And this particular NGO helped her have a micro grant so that she could start a small business. She left her husband and she started a small business in another town, and that micro grant gave her the economic sufficiency to be able to live. Well, that allowed the other women to see that this was a real possibility, something that they had all accepted. They knew it was illegal. They knew it wasn't right, but they didn't know how to do anything about it, and they didn't have any examples of how change happened. But once one woman had the bravery to stand up and say, look, I'm going to start a business and I'm going to leave this horrible situation, I'm going to take my children out of this bad situation, then other women could see that. And so the cultural change could start happening. And I think when we're talking about human change at a human level in small society, in small cultural units like a village, we also need to be thinking at that level, not just at the legal and not just at the political, but at the who's the example, who's the hero that these other people can look to see that change can happen. On competition and innovation and rule of law, I think of that as competitive and innovative. I feel like looking at those kinds of levels, Hill in The Hague does a lot of work on innovation, and I think they do really, really smart work on this. I think the more innovation, the better. That the state has a monopoly of power and the rule of law, and that's sometimes good and it's sometimes not so good. And the more that we try to push for the human rights and the justice, rather than just the state's role, the more options we have. And finally, are the red lines of human rights good and useful? I think I agree with my other panelists here that there's not enough microphones in the room at the human rights discussions, and that's a pity. My background, I started in human rights. But I think because there aren't the microphones in the room, we need to move the human rights discussion to where there are the microphones. And so in the same way that the legal issues for women are dealt with in the health areas where the women are willing to come, we need to take the human rights issues and infuse them throughout the other issues that we work on, which ultimately get back to human rights, rather than try to make everyone speak a language of rights that isn't necessarily the way in which people are comfortable speaking.
Great, thank you. We can have another round of Q&A. We've got over here, Bill, and then back to you.
Thank you, Bill Pace with WFM and the Institute for Global Policy. Well, first I want to just say that you can't, in my mind, read Goal 16 and not include human rights, rule of law, dimensions to it. It's not credible to read it otherwise. But a couple of questions. Is not the challenge to get to the rule of law and beyond the rule by law multidimensional, while most of the diagnoses and prescriptions are very much remain two-dimensional? And do the panelists see that there is an indispensable interdependence and hopefully synergy between the promoting the rule of law between different levels of political society and governance? So from the village and local to the provincial to the national to the sub-regional, regional, international, global. Are we really looking at the tapestry, the three-dimensional tapestry that has to be addressed? And does not the rule of law, for example, the UN Charter, need to be also enforced at the global level and international level? And quite honestly, 3 of the most powerful countries, 3 of the permanent members of the Council, have committed aggression in this last 15 years with impunity and with no legal repercussions. And this is one of the fundamental, I think, challenges of the rule of law agenda. And our biggest project, our most prominent project, is the Coalition for the International Criminal Court, over 3,000 NGOs, 150 countries. But we have had enormous difficulty getting any kind of support because of this 70-year separation by real walls between the development work, the humanitarian work, and the human rights and the peace and security sectors. And will Goal 16 be a platform for finally building bridges between these sectoral walls that have existed. Thank you.
Thanks, Bill. Big questions. Yeah, right behind there.
Hi, my name is Marike, and I'm the Rule of Law Advisor at the Dutch Foreign Ministry. Thank all the speakers for wonderful presentations. My question is, I think to Rachel, I'm missing a little bit Pablo de Greve on the panel. And what I was wondering is the connection between transitional justice and rule of law. I think for some reason these fields developed a lot in isolation from each other, but that actually in the transitional justice field, there are many lessons which are taken over the years, including the need for transformation, the need for consultation, the need for flexibility and innovation, etc., that we don't necessarily see developed in the rule of law field to the same way. I think your book is dealing with legacies of violence and countries coming out of them. So do you draw that connection, and do you think there's significance there?
Great, thank you. We've got two in the back row there next to.
Very good morning, all. I am Samarth Khanna. I am an intern with the International Legal Foundation. My question is an offshoot of the second question, which was asked on gender justice, and it's targeted towards Advocate Hussain. Ma'am, don't you think a more effective implementation of rule of law and gender justice would be the codification of personal laws? First, and second, is personal law codified in Bangladesh? And if not, has the civil society there taken any step towards the same? Instead of rather pressurizing the civil society and the government exchequer in providing services, shouldn't there be statutory limits which do away with inherently patriarchal practices and customs and codify personal law? Thank you.
Hello, my name is Megan Price. I'm from the Klingendal Institute in The Hague. I really want to applaud all of the speakers. I thought not only were your contributions really inspirational, but very much in the current of where I think we need to be going. I really like to think about the pursuit of the rule of law as really a pursuit and a project of expansion, and expanding not only the protections that we offer to our citizens and people, but also who we consider our citizens and who we consider the public to be. And I think that this new attention towards the fact that that's also a cultural project is really important. But I want to draw attention back to the fact that if this is our ultimate goal, we can't, we can't leave states in the lurch a bit. They need to not only be able to theoretically offer these protections, but also actually guarantee these protections. So there is obviously still the role for some technical assistance. And if the question is not necessarily either or, more of an and, we have a cultural and a technical approach to this problem, what does that mean for how we divide resources or expand resources? How do we address member states to accept this expansion of the project?
Great. Thanks. I think we'll just keep gathering, and then we'll come back for final comments. Okay? Because there's a few more. There was one more back there. I think next in front. No. Oh, yeah. I'm going to come to you. I know that you've been there.
Hi, I'm Diana Goff also from the Klingendal Institute. Something that I was really hearing in the presentations today was not just to think about the role of politics in the rule of law, but also the role of empowerment of people to make these changes themselves. And I'm wondering, to what extent are we in this field connecting with the science of empowerment, the psychology of that? So I think we touched on it a bit, but are we really connecting with that other area of research?
Right. And just in front there of her, I think you still had a... No. Oh, no, she doesn't have it.
All right, thanks. Good morning. Terrific panel, great responses. My name is Francis James. I'm working on Haiti. 20-year timeline, check. Partnerships, yes. Coalition building, yes. Civil society, women's group, yes. Investing in people, mid-level, got it. Haiti, we've been doing that. We've been doing that for a long time. And, political will, not there, perhaps. Civil society's pretty fractured. Rachel, I was really curious, your last, pulling the different levers. So political will is not available, pull the social level. Social lever, pull the cultural lever. I think we've been pulling the levers left and right, and it's not working. So I guess my takeaway is welcome failure, keep trying. You never know, plant a seed, something may take in the future. But then control the narrative in the future. I'd just like your reaction on that. Thanks.
We'll take one more, and then we'll come back to the panel all the way over in the back.
Thank you very much. My name is Åsa Wallenell, and I'm from the Minister for Foreign Affairs of Finland. I would like to thank all the panelists for these excellent recommendations that you came up with, particularly in strengthen our own assessment of political economic assessment in programming, the sensitivity to human rights that should guide us, the sensitivity to gender equality, and to use these kind of issues to bring out the red lines in what we're doing. But I would have a question to Richard. You mentioned that we need to be aware that we need to have a political goal, and we need to, as international actors, we need to become political ourselves. How do we balance that with being neutral in the context and being objective at the same time as we get engaged politically? Thank you.
Great, thank you. Excellent questions. So we'll come back. We'll come back to the panel for your responses and also sort of any closing wrap-up remarks, and then we'll come back to the Assistant Secretary General. And we'll do it in reverse order here, Rachel, so you don't have to go last this time.
I was all prepared to have some more time to think. Well, let's see. I'll start with the question focused on me, and then I'll sort of branch out from there. So on transitional justice, having lessons for the rule of law field, absolutely. And I feel I must say that I don't particularly like silos. I started in human rights. I moved into microcredit and development. I learned from that people were being prevented from doing microcredit in northern India because of immense violence from landlords, and I got into rule of law. And to me, what you're trying to do is create healthy individuals who are empowered in healthy societies, and these things all go together. And when I started at Carnegie 3 years ago, I told, we have our own program assessments, and I said, for the first 3 years, I'm really going to work on building a field of rule of law that draws on all of these different expertise, and we talk to one another, and all of these beautiful things happen. And I failed utterly. So utterly that I actually had to put in my performance review that this goal was 0% fulfilled. It was really quite embarrassing. I think that the level of siloing in this field is just stunning to me, and I don't really understand it, to be honest. It seems to me that you can't talk about rule of law in a country without discussing transitional justice if the country's been through conflict. You can't discuss transitional justice and rule of law without looking at some issues of development. And so I find it baffling, and perhaps that's part of why I made so little progress. It helps to understand the problem better. But I agree that we need to start talking to one another. On how the SDGs could break down these barriers, boy, I hope so. I think that it is one of the things that we're starting to see. All of a sudden, we're starting to see rule of law being discussed in political contexts and so on. But I must say, I've got a paper due later today on why the SDG 16 Target 1 should contain conflict statistics. For those of you who don't know, there's been a move to move conflict statistics out of the violence goal, a violence target of SDG 16 for political reasons. And, that seems kind of silly. Take the conflict community out of fighting violence everywhere. So I hope that the SDGs manage to do that. I'm not so sure that they will be able to do that. Megan, your question on not leaving the technical fully out, you're absolutely right. And I'm afraid sometimes we in the think tank community like to make things clearer than the truth because you're fighting, you're pushing against something. But the reality is these countries have technical challenges. Many, many places have technical challenges. It's simply that the technical challenges are springing from political problems. The political problems won't be solved by solving the technical problems. And so I think it's really about ordering, and prioritizing. So if you haven't solved the political problem, throwing money at the technical is just not going to do much good. And I don't actually think that you can move the political needle by focusing on the technical. But once you have a willing government, then absolutely you need to start moving on a lot of the more technical problems that government's having. So it's just really about ordering. On empowerment and psychology, I'm so glad you brought this up. This is something that my mother's a psychologist, and I've always thought about this quite a bit. There's a woman named Vivian O'Connor who I think is still at the U.S. Institute of Peace. I'm not positive. She lives here in New York. But she is starting to write about this, and she's done a great deal of research into trauma victims and how you help overcome trauma, empowerment issues in psychology, and ultimately that's where a lot of change lies in individual brains and how those brains decide that they're going to move into being change makers. There's an organization called Ashoka that does social entrepreneurship. And they have a program called Everyone a Changemaker. And I've talked to Bill Drayton, the CEO, quite a bit, and said, do you really mean that? Because in my impression, most people don't want to be change makers. Most people would rather not be at the forefront of change. That takes a lot of risk and it takes a lot of energy to do. And a lot of people would rather coast at various points in our lives. And he was saying, well, I think we need to move to a mindset in which everyone feels empowered to be a change maker. And what does that mean for individual psychology? So I think you're right that we need to think about that a lot. Reaction to long periods of failure, despite the fact that we're trying everything that we can. I guess I'm an optimist, and I look at stories like David Tusabashvili and say, well, that was a failure, but it was also a success. And that, as you're saying, maybe you call that planting seeds. I think that we have had an awful lot of successes in change. I was hiking I live in Colorado, and I was hiking with a friend of mine talking about a program in Honduras that I was working on, that Honduras, had the highest murder rate in the world. It was having political assassinations. They were having all sorts of issues with their security sector being used to kill individuals. They had a huge drug cartel problem, and some of the drug cartels had taken over the indigenous groups that we were going to for advice. So when you'd go to an indigenous group, you were really talking to the drug cartel that had elected people. I mean, just incredible problems. And my friend turned to me and said, don't you get depressed working on this stuff? And I said, well, but look at all the countries that have gotten so much better just in our lifetimes. And when you look at that, you think a lot of places can get a lot better. There's been enormous successes. There's a really famous, I forget it, there's a show on development that, like a little web show that's quite famous now, that shows all the development statistics getting better in so many countries around the world. And Steven Pinker in the field of violence has written about this with regards to violence, that violence has come down enormously since the Middle Ages over time. And we look at these little blips and we get very upset, and we should, because Syria is one of those little blips. But in the grand course of human history, life is so much better. And that's an enormous success, and I don't think we should get discouraged that we're just playing along the margins. We're making a big difference.
Great, thanks. We've got about 13 minutes left, and we also need to give, yeah, great, thank you.
Thank you. I think I also agree that transitional justice approaches absolutely would apply, and particularly I think around in terms of focusing on the fact that you're searching for truth, accountability, and you're trying to build society together, keep it together, and build a narrative that people can get behind. That's a very important aspect to look at. On the specific question around personal laws, I'm not sure codification as such is the answer. I think it's more about the process and how do you, firstly, how do you get a commitment to working around reform, and with universal human rights as your framework for that. But how do you engage communities in the process of reform? Again, this really is about the politics as well. If you're in contexts where minorities feel extremely disempowered, where they're under attack, then building minorities into the process of change is important. But at the same time, that can't be an excuse for stagnation, because within minority groups, there are women who are facing the brunt of discrimination. So including them in that process of change is absolutely critical. So codification can be helpful, but I think not necessarily the only way. And that also, I think, makes us look at questions of intersectionality at different communities and how they're being impacted, or people with their different identities and how they're being impacted by discrimination. The question of legal empowerment that was brought up at the back, and empowerment in general, I think that's very important. I think in a way, actually, as we're looking at the SDGs, we also have a bit of a risk that we can also forget about empowerment. We can be looking at outcomes and sort of economic outcomes and forget that empowerment is an end in itself as well. There's some interesting research that's recently come out that some colleagues and I are arguing with, that's come out from a body called Copenhagen Consensus, I think. And it's done some research around child marriage, where they're showing that the biggest investment you can make in child marriage is actually cash transfers and stipends. And the lowest bang for your bucks you'll get is if you put money into legal empowerment. And we're actually arguing with this quite strongly and saying you can't simply be seeing that as an issue around investment. You must see empowerment as an end in itself, because as Rachel was saying, those who, the women, the young girls, other marginalized groups, groups who are going to be parts of process where they're engaged in empowerment will be the ones who make the change happen in society. They will be the ones. That is the process of cultural transformation. And that's something we have to be invested in socially and economically. Neutrality in politics, very good question. How do you maintain that? I don't know that we have clear answers, but I think the neutrality issue is around, again, using universal human rights standards as the touchstone. I mean, at the risk of overstating that. And finally, I think the context is around making cultural change as much as social and political change. I mean, when we are talking about contextual, looking at the context, as I think the speaker from, our first speaker from Russia also said, looking at the context, looking at the country, but within that, making cultural change happen. Because without that, really, we're not going to see the other levers also operating. And that's the lever that's the deepest and the strongest. And in a way, the hardest to shift, but also the space that remains. And I think that links in again also to going back to the issue about shrinking civil society, that one of the reasons that the attacks on civil society, I think, are also there is precisely because there's such resistance to a change in culture, which is also coming from there. So I think that's one of the places that we should be focusing on the most. I'll end there.
Great. Thank you so much. Ricard, the last word.
I'll be brief, I think, but just adding something on political will, since we all touch upon it now. It's important to have a nuanced understanding of political will. So it's not monolithic. It doesn't sit here and not there. It's everywhere in that sense. And we need to break that down. I think the lever metaphor is a good one. And that resonates with how we understand what we know about how change happens in relation to institutional change or societal change. It happens through some plurality of different actions that are not always accounted for or could be determined from the onset. They just happen sometimes. And some of them we know, some we can support, but others will just happen. But the plurality is important. For a long time, rule of law has acted on the principal-agent theory. So the principal had a problem with agents and can't really control them. To strengthen the principle, you need the principal's political will to engage. But that's not really how things work in terms of change and change management. I think that brings to the issue of empowerment psychology and empowerment and the leadership issue that we have talked about this morning as well. So looking at different forms of leadership in different sets of the state and outside of the state as well. And I think that's important. I think the good example you mentioned on child marriages, really what you touched upon last was finding alternatives to that, which is really about sometimes very non-legal actions, but finding alternative to something that is a rule of law issue, and that you attack from different, a plurality of action, from criminal law to stipends. I think that's a really good one. Then on the multidimensional issue, I think Rachel touched upon that as well. I think absolutely, and SDG, hopefully yes as well, that it will bring that about. And I'd like to bring attention to one issue that I haven't talked so much about, which is, again, the boring stuff, not competence provision, knowledge management, but public administration and governance as an issue in relation to rule of law. At the Folke Bernadotte Academy, we've been working for quite some time of trying to make the link between, on the one hand, rule of law, and the other hand, public administration. Benjamin Franklin's, one of his many famous things that is there, so nothing is certain in life but death and taxes. In between, you have public administration. So really, I mean, we all have been discussing as well to go at where the rule of law hurts the most. It may be in relation to police or lack of security provision. It may also be, in many places, lack of proper land documentation or not accessing services of an administrative nature. It's important to focus in that regard too, and then not to do it as has been typically done from an organizational management or efficiency point of view, but also from a legal qualitative point of view in relation to administrative services. And on Megan's point, we're certainly not advocating for focusing more on the cultural and less on the technical. And FBA also as a seconding agency, I have to say this is his webcast. When we do second technical expert, and we want to continue to do so, they have a centerpiece role in reform efforts, but they need to be complemented. And then, well, how to do that? Well, it's about recruitment strategies, team composition, balancing them with different disciplines that can complement the very technical, sometimes legal expertise that is also desperately needed. Finding ways to do that, finding ways of doing evaluations and midterm reviews in different projects in order to capture not just the legal outputs, but also other aspects as well, and to be sure that you have that from the beginning. One of the key messages we want to leave with you as well is that when it comes to thinking and working politically in rule of law reform, particularly for agencies like UNDP. Don't let perfection stand in the way of good enough. Being a little bit more politically informed is better than not at all. So use what's there and use it smartly. So capitalize what you have already in your system, like the peace and development advices, as an example. Lastly, on neutrality, I think for some neutrality is not an issue in that sense. I mean, looking at development assistance generally, and it's certainly a balancing act, of course, of maintaining that neutrality between not interfering to a great extent. At the same time, what we are talking about when we talk about thinking and working politically, it's not political interference. It's about sort of political smart ways of anchoring and supporting what is national and local reform priorities at different levels of the state as well, where you find them. Okay, thank you.
Great, thank you. This has been a tremendously rich conversation, really highlighting, I think, the multidimensional nature of this challenge and the need for multidimensional responses geared toward the long term and demanding an all-of-system cooperation. And I think I would echo the insight about the levers, both the political, the legal, and the social, cultural, and also I would say multiple levels, both at the local, the national, and also, as my friend Bill Pace mentioned, also at the international. The international rule of law is also an important part of this. I will now pass the floor back to Assistant Secretary General Bahous for final remarks.
Well, thank you very much. Actually, I don't have much to say after this very inspiring and stimulating discussion. I would like to really thank our speakers. And thank you actually very much, Rachel, Sarah, and Richard, for a very enlightening discussion, thoughts, experiences. Thank you, Adam, also for a good moderation. Having listened to the discussion and having been immersed myself in the background of some of the countries and the experiences mentioned, we have many takeaways today. I think many of them were mentioned here, but I'd like to say that the first is that we must be clear on our understanding, our shared understanding that political life has an important bearing on how the rule of law takes shape, and that therefore our support, whether it is technical or otherwise, needs to advance the rule of law and should be supported always by political analysis and by political awareness. I think it was articulated much better than me here with the discussions, but it's important to really highlight again. The second takeaway is that the development of rule of law is a long-term process. It is a long-term process. It is not a linear process. It is filled with risks, with ups and downs. This is especially the case in conflict and post-conflict settings where politics are especially fraught. We must therefore resolve to see support for the rule of law not as a one-off issue, but as a process that is continually infused by political awareness and by learning and adapting. We must continue to ask the tough questions. We must continue to learn as much from the setbacks as we do from the successes that we support, and we must be aware of the complexity of the institutions we are called to support and help, and of the political agendas that are most of the time at play, sometimes in the foreground and sometimes in the background. The third is the importance of UN leadership and coherence at the country level within the framework of national ownership. We need to take lessons on board, encourage and reward new cross-cutting and innovative ways of work that build linkages between technical and political engagement and that challenge predetermined assumptions and path dependency. I also would like to highlight that what was highlighted here, that we really need to keep thinking about and working on going beyond the experts and the specialists, involving the society, involving informal sector, paralegals, as was mentioned, communities, women, NGOs, private sector, continue to build partnerships, to build coalitions, to build the capacity within the people themselves, and also to help them create the networks that will help them to change and to become change agents as well, moving from as was mentioned by Rachel, from thinking politically to working smartly and politically on the ground, and also on working on cultural change, which is something that is also quite a challenge. Connecting transitional justice and rule of law is very important. I come from a region which has witnessed a lot of change in the past few years and still is, in particular in politics and in overthrowing certain leaders, putting others in place. But what about transitional justice? How do we bring that all together under and with the rule of law in these countries? The political will also, yes, a challenge, but we have to keep at it and to keep working on it as much as possible. Also, I'd like to say it is important to note that the work of UNDP and other agencies here does not happen on its own. We are most of the time invited by governments to help them on that, and this is where we see the national sovereignty and the national ownership being respected as well, as much as, of course, as possible. One good example actually, is in Tunis, where we were invited by the Tunisians to come and help them on transitional justice and on rule of law and on their whole trajectory of the democratic process that they are going through, and things, are going okay. And we feel that we can continue to support in that direction within the political realms of the invitation that we were given. I think also we need to, as we carry forward these initiatives, all of them as the UN and others, we will be informed by many discussions like the discussions we've had today, like the book that was mentioned, also which is outside. I invite you again to take more copies of that so that we can also keep learning and looking at doing research and more support and more bringing out the experiences into the open. I will not say any more except to thank you again, all of you, for your support, for your interest, and for your partnership and collaboration, to which we look forward to continuing and strengthening. Thank you very much.
Thank you.